The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker. It's an honour to rise in this House at the point of calling the question on Bill C-30, the bill that would bring in the Comprehensive Economic Trade Agreement between the European Union and Canada. I have the honour to represent the only party in this place that has voted against all investor-state agreements, although mostly the NDP votes against them. They don't always. And I would urge them to reconsider and ensure that for future, all investor-state agreements be rejected. They really have nothing to do with trade at all. And again, I want to dive into that aspect of the investor-state agreements, but touch briefly on the other aspects that Canadians should be concerned about. One is, as many members in this place have already raised, is the increased threat, the increased cost of pharmaceutical drugs. It's very clear that that will happen by numerous independent studies that have looked at the implications of the so-called CETA agreement on drug prices for Canadians. It's also clear, and has been raised by a number of groups, that the language that the European Union won in the text on the question of municipal powers of procurement will also be negatively affected by CETA, including in access to procurement for municipalities, academic institutions, school boards, and hospitals, that if they should decide they want to make sure they're buying locally, they could be offending the procedures, the provisions of the CETA agreement. But the part that really is the most controversial, and certainly the most controversial within Europe, it's why I think Canadian parliamentarians are being sold a bill of goods when we're told that there's any urgency here. I'm really surprised, honestly surprised, that the Liberal government chose not to have significant review and consultation nationally. We had that on the Trans-Pacific Partnership Agreement, but not on the Comprehensive Economic Trade Agreement with the European Union. This is surprising, given that there can be no need for urgency in Canada rushing to ratify when there's 28 countries and an additional 10 subnational groups throughout the European Union that have yet to ratify, and given that there is still a pending decision from the European Court of Justice as to whether the Comprehensive Economic Trade Agreement is compatible with European law. Now, the controversy within Europe is overwhelmingly about the one piece of this agreement that I think could be very conveniently and easily removed without affecting the trade aspects at all. So this does take some underscoring. What kind of trade agreement has an entire section that has nothing to do with trade? Well, the answer is these days almost all of them. We are being sold hook, line, and sinker the notion that trade agreements must include something called investor-state dispute resolution systems, or FIPAs, foreign investment protection agreements. The first of these anywhere in the world was Chapter 11 of NAFTA, and we have a lot of experience with Chapter 11 of NAFTA. I do not believe that even the negotiators of NAFTA believed that they were introducing anything novel when they negotiated Chapter 11. As much as Canada had a national debate on NAFTA, Chapter 11 never came up because it was a sleeper provision. It might have stayed asleep, actually, if it hadn't been for the ingenuity of a Toronto lawyer, Barry Appleton, who decided that Chapter 11 of NAFTA could be interpreted in a completely novel way. The essence of legitimate protection of investor interests in other countries is that you don't want a government coming along and nationalizing the assets, saying, okay, you've built a lovely refinery here, thank you very much, we're now going to say this belongs to the government of fill in the blank, and you as an investor don't get your money back on that. That's what people thought Chapter 11 was initially, because it talked about protections for expropriation. But Chapter 11 used some novel language. It talked about governmental measures that were tantamount to expropriation. And here's where the clever lawyering came in. Well, the first Chapter 11 case was when this Parliament banned the trade and use of a toxic gasoline additive where manganese was its operative. This manganese-based gasoline additive had a human health threat component. It also gummed up the diagnostics of the onboard catalytic converters for automobiles. So the car manufacturers were worried it would void their warranties. Environment Canada was worried it would cause more air pollution. neurotoxicologist like Donna Mergler at University of Quebec at Montreal was worried about it causing an increase in a disease that looks a lot like Parkinson's but is manganism. Well, this Parliament banned it. But because of a Chapter 11 of NAFTA challenge from a private corporation of Richmond, Virginia, Ethelcorp, Canada found itself in an arbitration case. This was just the first of many, and we keep losing them, or we keep having them settled out of, you can't call these places courts unless you use the word kangaroo first. These are arbitrations in hotel rooms with 3 private arbitrators. And they make money being arbitrators, and they're expert lawyers, and you can find Canadian lawyers who claim to be environmental lawyers suddenly selling out to be an expert lawyer for a U.S. corporation for these secret hearings. Now, the secret hearing process under NAFTA in Chapter 11 is egregious. Just as egregious is the Canada-China investment treaty. I'd have to say more egregious, because every investor from the People's Republic of China is going to be a state-owned enterprise for the People's Republic of China, so their ability to sue us is virtually unlimited. And this, of course, the Canada-China investment treaty never had even as much debate as we're getting on CETA, because it never went through Parliament at all, because previous Prime Minister Harper approved it in Cabinet confidentially, and it binds the Canadian government till the year 2045 that the People's Republic of China and its state-owned enterprise have a superior right to challenge decisions made in Canada than any Canadian corporation. So the CETA falls somewhere in between. CETA is being sold to us by many as the gold standard. It was the head of trade negotiations for the European Commission, Cecilia Malmström, who came up with the idea that, well, since this investor-state provision in CETA is so controversial and it's attracting so much protest from within the European Union, maybe we can make it look more like a real court. Maybe we can end the fact that it's so clearly for-profit driven. I mean, can you imagine arbitrators who one day are working in their big downtown law firms, and the next day they're essentially judges determining whether the decisions passed through parliaments around the world are going to hold up to their private scrutiny, with no appeal, no oversight, and no room for interveners to make the case for why it was appropriate to ban a gasoline additive, or stop the export of PCB-contaminated waste, or not put a toxic waste disposal facility next to a town's fresh water supply. These are all real-life examples under Chapter 11 where the polluters have won and the citizens have lost, and it happens over and over again. So CETA proposes some improvements, no question. Much better than Chapter 11 of NAFTA. Better than the Canada-China investment treaty, which we seem to have forgot ever even happened in this place. When I hear Conservative members getting up and asking whether the new administration under the Liberals is moving too close to China, I kind of want to, run over and shake them. Say, don't you remember? You guys passed in secret, well, your cabinet did, the Canada-China investment treaty, which is the worst of all of these. But Professor Gus Van Harten at Osgoode Hall Law School, who literally wrote the book on the bad investment deal with China, he called it, the book is called Sold Down the Yangtze, if you want to pick it up and find out how our sovereignty was sold out by the Harper administration. But Gus Van Harten's done a careful study of what is being offered in this so-called gold standard, and there definitely are flaws. Yes, the arbitrators will have a more permanent roster. Can you imagine if our judicial system picked judges at random from the private sector and they did better on cases where the rich guys won? Can you imagine how fair our judiciary would be seen to be? Well, CETA does make an improvement on that, and there will be a permanent roster of such judges. They're still drawn from private sector work, and although they are prohibited under the CETA terms from acting as advocates and lawyers before a CETA investment court, they're not barred from operating as advocates and lawyers under other dispute resolutions, such as Chapter 11 of NAFTA. So there is still this culture of an elite group of corporate lawyers who are literally global ambulance chasers. They find companies that they can say, guess what? You can sue that government if you want to. The sad part as well is that for a moment, Cecilia Malmström's proposal called for allowing civil society to come forward as interveners. That part of her proposed gold standard got dropped. So my plea to this government, and my plea to all parliamentarians, is to dig in our heels on this. I commend the NDP caucus for digging in your heels on this one. Dig in our heels and say, these are anti-democratic by definition. There is no chance in the world that a company that emanates from the European Union is going to expropriate Canadian property in Europe, contravening all the laws and international common law practice. We are in a safe zone here, developed country to developed country. Let's get rid of the unfair investor-state provisions and fix CETA so it's about fair trade. Thank you.
Questions and comments? Questions et commentaires? The honourable member for London Fanshawe.
Well, thank you, Mr. Speaker, and I thank my colleague for her remarks. There's an old saying that fools rush in where wise people fear to tread. And my question has to do with this rushing in order to sign this agreement. We know that CETA will not be fully ratified until all 28 EU member states have passed the agreement in their own parliaments. And so clearly we have time. And I would think that we should take that time. And I wondered if the member had any thoughts in regard to taking time so that we can address the issues of investor-state provisions and the very clear concerns expressed by CETA in regard to environmental degradation, and of course our dairy farmers and those who produce the good food that we rely on. Can we accommodate those folks? Can we slow down? Should we?
The honourable member for Saanich Gulf Islands.
And I thank my friend from London Fanshawe enormously. Absolutely, we should slow down. This is going to take a minimum of 5 to 7 years to get through the European parliaments we're dealing with. And we also still have the very substantial, some might say it's a risk, I say it's a hope, that the European Court of Justice will say that it is not in accordance with European law to allow Canadian corporations to sue European governments. We will, of course, we have the shoes on the other foot. Something like the Ajax mine that's being pushed in Kamloops, BC, that local residents don't want, is owned by a state-owned enterprise from Poland. If CETA doesn't go through, the BC government can turn down the Ajax mine without the risk of a corporate suit against BC that's taken at the national level, and goodness only knows how much money we could lose. I have to underscore this. The decisions under investor-state provisions have nothing to do with trade. They don't involve Canada doing anything quote-unquote wrong. That doesn't involve us violating any scientific principles or acting against evidence. We just have to be shown to have cost them money. That's it. It's completely corrosive to democracy.
Questions and comments? Questions et commentaires? The honourable member for Elmwood Transcona.
Thank you, and I'd like to thank the member from Saanich Gulf Islands for her speech, and just ask her, I mean, we know that when we look at European countries that had reservations about signing this agreement, and many have now signed, but with the proviso that they haven't yet ratified, and so the debate within Europe about especially the investor-state dispute settlement clauses is far from over. There are other aspects to this agreement that could be positive. There are some negative ones too, but I'm just wondering, who do you think is putting all this pressure to, if the investor-state dispute settlement clauses are what risk having the deal fall through in Europe, who's pushing for them? And if it's the Canadian government, why would the Canadian government be willing to risk the rest of the deal for the sake of keeping these provisions in here? It's certainly not many of the governments in Europe who are pushing for these. In fact, that's where they're getting the pushback from their own population on this deal. Who's defending these, and why is it so important to keep them in there if it jeopardizes everything else that Liberals and Conservatives say is good about this deal?
The honourable member for Saanich Gulf Islands.
Thank you to my honourable colleague from Elmwood Transcona. That is, as they used to say on the old TV show, the $60,000 question. Adjusted for inflation, I guess that's the $6 trillion question. It makes no sense to tie up what would be a, we do have issues with some of the trade aspects, and I'm glad my friend from London Fanshawe mentioned the dairy threat. I mentioned pharmaceuticals, the procurement provisions. But even the procurement provisions are not primarily about trade. What we're talking about here is increasing the powers of transnational corporations while decreasing the regulatory powers of governments. In whose interest is that? It's not in any sovereign nation's interests. It's in the interest of transnational corporations. It's the first plank of global corporate rule, and it's being advanced by the corporations. And this current government, the Liberal government, should look at who pushed it in the last round of negotiations, realize it was the Harper administration, not the Europeans, and take it out and start a rethink of all of these investor state provisions and renegotiate them so they make sense to defend the sovereign rights of governments to protect public health, safety, and workers' rights within their own countries.
Resuming debate, the honourable member for Elmwood-Transcona.
Thank you very much, Mr. Speaker. It's a pleasure to rise again and speak to CETA in this House, because I think there is a lot to talk about, and I don't think we've done a good enough job yet of discussing what's in this deal. There's a lot of platitudes from those who would support the deal, and I would say not a lot of information. We certainly haven't seen from the government any detailed study of what they anticipate the economic impact of this deal will be. Canadians are just supposed to take it on faith that somehow this is going to be good for them and for their jobs and for their communities. And I think it's reasonable that Canadians expect at any time, but particularly from a government who promised to make evidence-based decision-making and to bring a scientific approach back to government, that they would expect to get information and some analysis from the government in the particular ways that they think this deal will be beneficial, but we don't get that at all. Instead, we get just a kind of ideological repetition of the idea that these deals must obviously be good. So the NEP instead has been trying to offer an example of how you can look at an agreement, look at its details, and actually evaluate the various clauses and try to come to a conclusion about whether overall it's a good agreement for the country. And I don't think it's any secret that the conclusion we've come to with respect to this particular deal is that it's not on balance good for Canada, and I'm going to get into why. I think one of the things we need to do is to recognize, first and foremost, and it maybe sounds silly, of course you would think that this is the case, but when you consider the positions and arguments advanced by other parties, I think it bears repeating that trade deals are an important part of public policy. It's not like you have trade on the one hand and it's separate and divorced from the public policies of government, and then over here you have all the other public policies. Trade deals have important implications for governments, and in particular these kinds of comprehensive trade agreements set the economic framework and a number of other important rules under which government can or cannot apply other levers of public policy, Mr. Speaker. So consider, for instance, a previous trade agreement that Canada once had with the United States called the Auto Pact, where you had an agreement on the transmission of a particular kind of good, in this case automobiles, across the border. The people who negotiated and concluded that agreement recognized that trade deals were public policy. And so their public policy goals for that agreement weren't just to create more wealth for transnational corporations. What they said was that if we're going to sign a trade deal, then we need to enunciate what our public policy goals are. And an important public policy goal is to ensure that jobs are created within Canada and that goods being sold in Canada actually mean that Canadians get a slice of the production of that good and actually receive wages for the goods that are being sold in Canada. So when we talk about trade deals and different kinds and the values that can be represented in trade deals, Mr. Speaker, we have an example of not having to decide that simply because it's a trade issue, we need to just approve whatever it is that, let's face it, multinational corporations have negotiated with themselves because they're advising all the various governments that are involved in these negotiations, Mr. Speaker. And, you know, I mean, these are not negotiations where you have, you know, union leaders and people representing the interests of the environment and ordinary Canadians. They're largely negotiations with government representatives and the representatives of multinational corporations. They're meeting behind closed doors, and they're coming up with rules. And then when they come out of that negotiating room, we're told, well, if either you agree with trade or you don't, and this particular set of rules that we've gone away and negotiated behind closed doors represent the best possible scenario for ordinary Canadians. I think that's a laughable claim, Mr. Speaker. They never provide any evidence to actually back up that claim. We're just supposed to take it on faith. And when you look at agreements like this, it's not clear what the public policy goal is. Consider CETA, for instance. That's an agreement that we know, because it's been confirmed by a number of independent studies, is going to raise the cost of pharmaceutical drugs in a country that already has among the highest. So we need to go from where we are right now with respect to the cost of those drugs and find ways to bring it down. And we know that CETA moves us in the wrong direction. So what's the gain that we're making that offsets that loss, unless the public policy goal, perversely, of the government is to fatten the wallets of international pharma, Mr. Speaker? I don't think that's a defensible public policy goal, but if it's the goal of the government, let them say so. If not, let them tell us what it is that we're getting out of this deal that counteracts that for Canadians. If everyday Canadians are going to be made to pay more for their pharmaceutical drugs, what tangible benefit, because that's a tangible cost, Mr. Speaker, what tangible benefit can they expect to see? There are lots of other ways in which you could pursue, within the context of these kinds of trade agreements, other public policy goals. So you could say, for instance, Mr. Speaker, that because we want a green public transportation in Canada and with our trading partners, whether they be in Europe or the United States of America or wherever else, we'd like to have a firm commitment with timelines and penalties if these goals aren't met, to work towards a common charger for electric vehicles, for instance, Mr. Speaker. That would be a legitimate thing to do. Certainly, if a trade deal like CETA can pronounce on the minuscule details of municipal procurement, we could certainly reach a deal that brought its member parties together to pursue a common charging standard that would allow that industry to reach economies of scale, increase production, whether it's in Canada or the other member countries, and begin greening public transportation in those various areas. But we never hear about that because we don't actually get into a debate about what the public policy goals of a trade deal are. We're just told this is going to create massive wealth and it's going to be great for everyone and everyone's going to get a job after we pass this. The evidence doesn't support that at all. If you look at the historical record and what's happened to the Canadian manufacturing sector since the late 80s, early 90s, when we began signing these kinds of agreements, and no further evidence has been provided. So when we look at the historical track record, I'd argue it's not particularly good, and we're not being given any contrary evidence, Mr. Speaker. You might also say when it comes to labor mobility, for instance, these agreements tend to have lots of provisions about how companies can bring in their own workers from wherever it is that they come from to perform work here in Canada that ought to be performed first and foremost by Canadians that are looking for that kind of work. Well, that's not the right way to go about those provisions, Mr. Speaker. But we do know that there are labor mobility challenges. For instance, trade unions who have hiring halls have people here that are out of work, and there are places with demand in the United States, and those people can't get that work because in order to get authorized to do the work, they first of all need an employer, so they need a visa. But because there's an agreement where the employer goes to the hiring hall to fill their labor demands, the person needs to be cleared to work at the hall first. But until they're cleared at the hall, they don't have an employer. So they can't apply for the visa, and they can't be cleared at the hall until they have a visa. Now, there's a legitimate labor mobility issue, Mr. Speaker. We could be working to address labor mobility issues in that way, rather than in ways that encourage the import of temporary foreign workers who are then working only for that company and are, frankly, under a dictatorship of that country, because if they decide for whatever reason that worker is complaining too much about their working conditions, or if that company then doesn't pay them what they were promised when they came over, they can be sent out by that company. And so that's not a fair arrangement for those workers. It's not a fair arrangement for Canadians who are expected to then compete against them. And there are other ways to do that. But this doesn't come up when we're talking about these deals, Mr. Speaker. That's what the NDP is trying to do in this debate, is to say there are other ways of doing this, and there are other important public policy goals that ought to be taken into consideration when we pursue trade agreements. But successive Liberal and Conservative governments have failed to do this. And so that's the problem, Mr. Speaker. That's what we're trying to zero in on. We're trying to show that, yes, trade deals are important, trade is important, but there's more than one way to do it, Mr. Speaker. In fact, there's an infinite number of ways. This particular way, where we take away the ability of democratically elected governments in Canada and elsewhere to make decisions about health, environment, working conditions within their own jurisdiction and put them at the mercy of trade tribunals that are more concerned about whether transnational corporations are losing money than they are about the substance of those issues, is the wrong way to do it, Mr. Speaker. That's not to say that there isn't a way to do it, but it means that we have to ask more of our governments here in Canada when it comes to negotiating trade deals. Conservatives and Liberals alike have shown that they're not up to the task, and when we've seen a change in government, Mr. Speaker, we have yet to see a change in approach. We saw that when David Emerson switched from being the Liberal International Trade Minister to being the Harper International Trade Minister, and we saw it when this International Trade Minister hugged the former International Trade Minister on the floor of the House of Commons the day that CETA was signed. There's no difference between the two, Mr. Speaker.
Questions and comments? Question commentaire. The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I thank my honourable friend again from Elwood Transcona for opposition to the investor-state agreements. And getting back to the core of this, one really does need to ask, how did we become so ensnared in so many of these agreements that only privilege the rights of foreign corporations? Canadian corporations can't sue under such provisions if the Canadian government makes a decision that hurts their profit. But if we accept this agreement, companies from Germany or Poland or Belgium or whatever would be able to sue the Canadian government, as now the U.S. government, U.S. corporations can. People's Republic of China corporations can, and if the TPP goes through, another 9 countries' governments, corporations from those countries can bring these private cases against Canada. Would he agree with me that we need to reopen the whole bundle of investor-state agreements and renegotiate them globally to ensure that they fairly balance the rights of corporations versus the sovereignty of governments?
Honourable member for Elwood Transcona.
Thank you, Mr. Speaker. I would agree with the member from Saanich Gulf Islands that there's something fundamentally broken at the conceptual level with investor-state dispute settlement clauses. There absolutely is. Giving foreign companies the ability to intervene in areas of domestic policy making for which we elect democratically governments to do is just completely backwards. And the idea that somehow, in order for those companies to get fair treatment in Canada, when we have a whole body of common law and other international agreements that give reasonable assurances to those companies that they won't be treated unfairly, is also wrong. So what's added to that, though, is a mechanism by which these transnational corporations can use the threat of serious financial punishment to governments in order to direct their policy behavior. That's what's wrong about that. So it's not about fair treatment. That already exists under the law before you sign these agreements. This is about whether you're going to give these companies the hammer and the threat of using it to direct government policy. That obviously is wrong, and it shouldn't be a component of deals going forward.